All right. Good afternoon. This is Eric Hauge, Executive Director of Homeline, and we're joined by Homeline's Managing Attorney and Hotline Director, Mike Braw. And today is Wednesday, June 10th, and we're beginning our weekly tenant landlord law during the pandemic webinar that we've been doing each week since mid-April. Just a reminder of what Homeline is. We're a statewide nonprofit organization. Our main program is a free tenant hotline that renters throughout the state can contact over the phone or via email in up to 4 languages: English, Spanish, Somali, and Hmong. And all right, I guess that slide isn't there. Just a reminder that we're doing these webinars weekly for the foreseeable future, with updates on any legal matters that have changed during the pandemic related to tenant landlord law, and weekly for an audience of tenants and advocates and service providers on Wednesdays at 1:30, that's today. And then on Thursdays at 1:30, we do one for tenants, or sorry, excuse me, for landlords and property managers. All of our previous, or most of our previous recordings of these webinars are available on our website. I just put the link in the chat. Again, for the most part, we're doing a lot of Q&A. We only got 1 or 2 questions in advance today, so feel free to ask your questions at any point. But with that, Mike, I'll hand it over to Mike and he'll kick us off.
Thanks, Eric. We don't have that much new material to cover, 10, maybe 20 minutes tops that I'm going to talk at the beginning. And as Eric mentioned, we have 1 or 2 questions that were submitted in advance is all. So yes, if you have landlord-tenant questions, specifically COVID-19, and if we have time, we can answer any other landlord-tenant legal questions that anybody might have. Please do submit them, and there's a more than good chance that you're going to get your question addressed still today. Okay, so let's talk about a little bit about where we are in the COVID-19 situation. First of all, the moratorium on evictions remains in place. We're going to talk about a slight tweak to the governor's executive order on evictions in a second, but let's just say what the old rule was, and then we'll talk about what the new tweak to that is as well. First of all, the eviction moratorium, rent is still due. The governor's order was very clear, stating that rent is still due. Now we're into, let's see, it's June 10th, so the moratorium was started mid-March. Some people didn't pay rent in April. Some people didn't pay rent in May. Some people didn't pay rent in June. You've got some tenants that didn't pay rent for any of those months. That doesn't mean the rent isn't owed, that it's not due. It is still due. They might be amassing a sizable bill here. I'm not saying that tenants are doing that by choice, but obviously that's something that might be happening here. In normal times, a landlord would be able to file an eviction for non-payment of rent, and they wouldn't have to wait 3 months to do so. If a tenant is 1 day late with their rent in Minnesota, the landlord can go file an eviction normally. But the COVID-19 pandemic has created what is termed a peacetime emergency. And the governor has essentially banned almost all evictions during the peacetime emergency, which continues on, and we'll talk about how long that will go in a little bit on a further slide. However, there are a couple exceptions. Even now, during the COVID-19 era, a landlord can evict a tenant that endangers others, and we'll talk about what that means more in a second, or for a violation of a specific statute that was built in the 1990s, early 90s, and it says that a tenant can't have illegal drugs. There's a list of illegal drugs. Pretty much everything you'd guess would be there is there. Alcohol, if you're under 21, not on that list, is the biggest exception in my mind. Illegal guns, so there's a list of illegal weapons, sawed-off shotguns, automatic weapons. You've been convicted of a felony. Once again, there's a list. Contraband, which is referring to stolen property, possessing stolen property, or prostitution. So those are all still reasons that a landlord could file an eviction today. Even during the COVID-19 pandemic peacetime declaration, where the evictions in general are banned. The landlord must also stop terminating residential leases during the pendency of the emergency This is something that we have talked about, I think, virtually every session that we've done since we started. I don't know how many we're up to, 6, 7 of these sessions that we've done now. Because the governor didn't say just that a landlord can't evict. An eviction is a court action, unlawful detainer, UD. A landlord is paid $300 to file the case. Is an easy way to figure out what's an eviction and what's not an eviction. There's actually a court date set. But the governor's order also says that a landlord cannot terminate residential leases during the pendency of the emergency. And in past sessions, we've talked about what we think that means. Look, I'm a lawyer. We have several lawyers in our office, and we do nothing but landlord-tenant law. But we're trying to interpret what this phrasing means without the benefit of any court decisions. There's no precedence for us to look at to figure out what this means. If you go down to the next point here, the Attorney General's office is the office that is tasked with enforcing this law, not just the eviction moratorium, but also the ban on terminating tenancies. And in prior sessions, we were sort of making our best guess as to what we thought the governor's order meant and whether the Attorney General's office would enforce the situation where a landlord terminated a lease for the future, but told the tenant about this now. Most leases in Minnesota require a landlord or a tenant, if they want to end the contract, to give notice to the other side, whether it's 1 month or 2 months. Some notice has to be given in advance, in writing, to the other side, saying, hey, we're not going to renew this contract. And in the last week, I have actually seen a letter from the Attorney General's office to a landlord on behalf of a tenant saying, hey, you can't give a notice to vacate during the emergency declaration for a time to vacate after the peacetime emergency declaration is over, which is problematic from a landlord's side of view for a couple of reasons. First of all, we don't know when the peacetime emergency will be declared over. Again, we're going to talk about that in a second, but it's been renewed for a few times. It may be renewed again. So a notice to vacate or a notice to quit or a non-renewal notice, they're sort of called all the same thing, or used interchangeably, might not be valid just with the first reading, because if a landlord gave a notice to vacate or a non-renewal for the end of May, and the tenant was still there on June 1, the landlord can't force the tenant to go because it's clearly terminating the residential lease. The harder question has always been, what about a future non-renewal past when the peacetime emergency eviction moratorium was still in effect? And we're starting to see the Attorney General's office at least threaten to enforce. I haven't seen any cases filed, but I'm guessing that in almost every case, the landlord is simply backing off. The language that I saw in the letter from the Attorney General's office referred to the fact that the landlord could wait until the peacetime emergency declaration was lifted and then give a notice, almost advising the landlord how to do this right versus continuing to do it wrong. And so the landlord fairly unsurprisingly backed down. The penalty against the landlord for violating this executive order is up to $1,000 and up to 90 days imprisonment. So it's pretty steep. And the Attorney General's office is calling people, landlords all around the state on this issue, trying to make sure that landlords are following the rule. Okay, let's go on to the next slide. Oh, sorry. Oh, just there you go. There's only one item there. As I mentioned, there was a tweak to the language in the governor's moratorium on evictions that I think it was done Friday night, if memory serves. Where the governor announced that this change would be, now I've only listed this version of the change once. There's actually 3 parts of the eviction order that the governor originally issued that refer to this same language, the safety of other residents. And it has amended or altered or edited, however you want to phrase this, the language in all 3 spots. So this change of language is mirrored in 3 areas, but it's all in the same original executive order that the governor had given on evictions. So here's the change that we have. So it says, the original version was the safety of other residents. A landlord could evict if the tenant seriously endangered the safety of other residents. Okay, so that's pretty limited. That would not include a landlord, for instance, if the landlord doesn't live on site, although they might be able to get a restraining order or an order for protection. And so it is limited to just residents that live in the building. And now the new language, and we'll just walk through it, or where the tenant seriously endangers the safety of others on the premises. Okay, so that's not just other residents. It's not just other residents and the landlord. I think it would be people like delivery people, or whoever's delivering the mail. I think it would be a very broad list of others that might be in danger. And then it goes on to talk about what the premises essentially means. So including the common area, so that would be a hallway or where the mailboxes are or something like that, or a lobby-ish type area depending on the building. And the curtilage of the premises. Okay, so I'm a lawyer, I went to law school, and I've certainly seen the word curtilage, but it's been a long time since it's been in my line of work. I do landlord-tenant law, and that's all I do. Curtilage you will see fairly regularly in the criminal law setting. This is a phrase found a lot, or a word found a lot, on Fourth Amendment, federal Fourth Amendment search and seizure cases, where it talks about where did the police have the right to search without a warrant or with a warrant. And curtilage is almost always tossed into those cases or statutes, and the analysis frequently talks about that. There are, in fact, cases that more or less spend their time defining what curtilage means. But it's a pretty broad sort of umbrella word. It's certainly going to mean if there's a garage that's not attached to the building, but it's still on the property that's owned and used by all the owned by the landlord and used by all the tenants. That's certainly going to be counting as the curtilage. Probably all the if you look at a taxpayer website, a county taxpayer website, and you sort of look at the space that particular parcel encompasses, probably all of that area is going to fit into the curtilage. I don't want you to necessarily quote me on that because, like I said, I'm not a Fourth Amendment attorney. That's a criminal law attorney, and in fact, that's sort of a subspecialty for criminal law lawyers, is to be a search and seizure expert. So if somebody really wanted to define curtilage, that's where you'd go to for the expertise. It goes on to say if the serious endangerment of others who are not residents is a material violation of the lease. So this doesn't give the landlord any new rights to evict. The right to evict for this sort of thing had to be built into the lease already. Most written leases are going to say something that would essentially cover this, I think. Not all written leases. I read leases almost every day that I work at Homeline. I get most of our emails are sent to me. And I've looked at, I'm sure, thousands of leases over my career. And some are incredibly elaborate, 40, 50 pages. And others are, and I'm not exaggerating, are written on cocktail napkins. And so the cocktail napkin leases, or a really elementary basic lease, probably this might not be there. The landlord might not have any extended right to file the eviction without that kind of phrasing in their lease. A lot of written leases would have this, though. Big picture, does this have a massive impact on landlord-tenant relations and eviction potential during the COVID-19 epidemic? My view is not really, no. There were not a lot of evictions that were filed under either the earlier version where it said other residents, or the drug, gun, prostitution, contraband rule either. Evictions have effectively been paused in Minnesota since COVID-19 came in and the eviction moratorium began. A landlord that wants to go this route certainly can if they have the facts on their side, but it's not an easy case to win. And most landlords, if they have a rock solid case, they simply threaten to evict the tenant, and then the tenant goes in most situations. So this statute, normal times, not used, or this type of approach is not used in normal times all that often for the landlord. And even in COVID-19, where landlords have no other recourse to file an eviction right now other than this, it's still not happening much at all. Let's go on to how long will these orders be in place, if we could, Eric?
Yeah, and I wanted to add one and clarify one thing. Again, you mentioned this already, that this language is repeated 3 times in the order. So it counts for, you cannot, the suspension of evictions, of actually filing those evictions, can happen in these situations. Also, termination of the lease. So that's just like a lease non-renewal or notice to vacate. And then also for writs.
Yeah, the writ is the order that the sheriff gets at the end of the process. I guess that would matter if a landlord already had a pre-existing writ, is going to be the most important time for that, but that's unlikely. The last eviction cases prior to COVID-19 were early March, and so uh, I think it's unlikely that that's going to be a real key component right now. The bigger question, the biggest question in my mind, is how long does the eviction ban last? Okay, so today is June 10th. We will know in 2 days whether the governor is going to extend the eviction ban. So the extension could happen in two ways of the eviction ban. The peacetime emergency, once again, is the key thing. I always want to cover this because we've all seen the dials that you'll see in the newspaper or online, how things are being reopened. I think it might be today that restaurants open. Is that right, Eric? Top of my head, that you can open half for some limited capacity.
Yeah, I think so.
Maybe even movie theaters as well. If you've been following that sort of thing, the shelter in place order has become more of a shelter in place, almost suggestion / guidelines on how to shelter in place and open effectively and correctly going forward. That has nothing to do with the peacetime emergency. It's a different order. It's a different time frame that we're following as well. And so the only thing that matters for the eviction ban, none of the shelter in place stuff matters. None of the dials matter. The only thing that matters for the eviction ban is either the governor decides to end the eviction ban completely. So last Friday, the governor unilaterally tweaked the eviction order. The governor, if the governor wishes to, could continue the peacetime emergency, I suppose, and lift the eviction ban. Just say, I'm going to end the eviction ban. The peacetime emergency is still in place for the other reasons, because the peacetime emergency is not just about evictions. It's about many other topics. But anyhow, the governor could unilaterally lift the eviction ban. The state legislature could also end the peacetime emergency, though, which would end the eviction ban too. So if the governor decides to extend again, we're in a new time for extending the peacetime emergency. What's different now is the legislature is not in session. The last two times there was an extension of the peacetime emergency, the legislature was in session. And at that time, if the Senate and the House, both chambers, decided to end the peacetime emergency, they'd both have to vote on it and agree to it. And I think it's a simple majority. They don't need some sort of super majority, 70% or something like that. It's just if they get more votes than not, they can end the peacetime emergency. But right now, the legislature is not in session. Their regular legislative session ended back in May. So if the governor extends the peacetime emergency now, by law, an immediate special session starts or commences. And that's not the normal way things work. First of all, the peacetime emergency is not normal. That's not what we're used to dealing with. We've seen special sessions, almost every year, I think, for, I don't know, maybe the last 20 years, it feels like. I'm sure it's not that high a number, but it's been a lot of special sessions. We've seen government shutdowns over that time that usually are where a special session has been kicked around and eventually there's some sort of agreement put in place and then a special session is called and then the legislation is set and it's ratified by the governor pretty quickly. So most special sessions are pretty fast events. But here's how special sessions work. If the governor has the power to call a special session, or in this case, if there's a peacetime emergency extension, it will happen immediately once the governor declares a peacetime emergency. But what the governor doesn't have the power to do is to end the special session. So once a special session starts, the legislature can do anything they want. I mean, it doesn't mean the governor is going to sign it and put it into law. But the legislature can pass any legislation that they wish to. They can take up any bills. They're not limited to just this issue. But if both the Senate, which is controlled by Republicans in Minnesota, and the House, controlled by Democrats here in Minnesota, both vote to end the peacetime emergency, that ends the peacetime emergency over the wishes of the governor. So there's a few different ways the eviction moratorium could last. But I mean, people ask us literally every day on the hour right now, when they're calling our tenant hotline, that's the kind of question we get, will the governor be extending the eviction moratorium? And the short answer that we have is we don't know. We never know. We have never known on any of these. We have been asked by various levels of government about all kinds of different things over the years. And we have contacts in a lot of different offices. That doesn't mean that we have the ear of the governor, or we are able to hear what the governor is thinking out loud. As near as we can tell, the governor's kept this pretty close and not disclosed it to many people, typically until the day of or even the night of the end of the peacetime emergency. The last time in May, the governor didn't announce this till about 6 o'clock at night, that the peacetime emergency was going to be extended. So that might be what happens again on June 12th, is that there will be an announcement either way. And if that happens, if the governor decides to lift the peacetime emergency, there won't be a special session, and the eviction moratorium would go away, and landlords could file evictions effectively on June 15th when the courts open back up on Monday, versus trying to go file a case on that Friday. June 12th is a Friday, so it would give a little more time before things could happen. The last point I wanted to get to is the CARES Act. I think we still have that in here, I believe.
Yeah, I was just going to add
Yep.
two quick things. I think what's listed on the slide is not correct. It's 20-53, and I put a link in the chat. That's
thank
the
you
most
again.
recent one. That's so 2035 was the one I think in April to May, and then 53 is the one that goes May to June. And the other thing I think that might be a possibility is that if it's lifted again, 20-53 goes until I think like 11:59, right before midnight on Friday the 12th. I think electronic filing of evictions potentially could happen
Right.
as soon the next day.
It doesn't. Yeah, I guess that's possible. And why that matters, that nuance is landlords are guaranteed when they file an eviction, normal rules, not COVID-19 rules. They're guaranteed an eviction hearing within 14 days of filing a case. And so if they were to file on the weekend, I guess, they might be promised a court date by not the next Friday, but the Friday after that. So 13 days away. Problem from a landlord perspective is they still have to serve papers correctly. And that's not necessarily easy to do. The tenant gets at least 7 days notice of an eviction. So it rushes the serving process, which might not be that simple. So I'm not sure that a landlord really wants that, nor am I positive that courts are going to be able to meet that 14-day requirement. The legislature has passed, and this is a law now, that courts don't have to meet statutorily required deadlines. We've heard from some courts, most notably the Hennepin County Housing Court, that they were planning to meet that deadline, that 14-day deadline, which I think is incredibly ambitious, depending on the number of cases that are filed. This is something we've opined about since this all began. How many evictions are going to be filed when the floodgates open up again? Normal years, there are between 15 and 20,000 evictions filed in Minnesota. Not all of those are for residential places. A lot of them are for commercial settings where you've got some business renting a space. But 13 to 15,000 residential evictions is our best guess. There's a chance, and we don't think we're exaggerating this, that it could be thousands, if not tens of thousands of evictions filed within the first week. In other states where the eviction floodgates have opened already, landlords have been lined up hours before the courts open to get their place in line, like it was tickets to a really popular group for a concert or something, and had their stack of cases to file against all the tenants that hadn't paid rent. And so our very real concern is that there's going to be a flood of evictions. That's bad from my perspective. I'm a tenant advocate and I work on behalf of tenants. I'm also an attorney, technically an officer of the court, and I'm very worried about courts being able to handle cases adequately, not just being efficient and getting through the cases quickly, but making sure that they're doing them right. And so, which is always a concern that our office has about evictions, that they're not just rushed through. The last point we should talk about when it comes to the eviction moratorium is, normally when we talk landlord-tenant law, we're talking almost exclusively Minnesota law. However, there is a federal law that plays a huge role in landlord-tenant law right now because of COVID-19, passed in late March. The CARES Act, which we've all heard of, has a ton of components to it, but there's a housing aspect to it that matters quite a bit for what we're talking about. And it bans evictions for non-payment cases. The Minnesota eviction ban would also work for breaches of the lease, like an unauthorized occupant, a boyfriend or a girlfriend, or a pet when you're not supposed to have a pet. The CARES Act is just about non-payment of rent cases. It bans late fees, which the Minnesota rule does not. And it lasts until July 25th. So a landlord can't file an eviction under the CARES Act until July 25th. And even then, they have to give a 30-day notice. So that basically means a landlord can't file an eviction until late August if the CARES Act is in play. Now, where does the CARES Act matter? Well, pretty much any kind of federal subsidy or subsidized place is going to have CARES Act protection for the tenant involved. But it also would work for vouchers, Section 8 vouchers. It would work for low-income tax credit properties, Section 8 project-based. And here's the really tricky one, which is properties that, smaller buildings, 1 to 4 units, where there's a federally backed mortgage loan. Fannie Mae, Freddie Mac, we've all heard those names or phrases. And if the landlord has one of those mortgages, then they can't file the eviction. They are stopped by the CARES Act. And so what has happened in most other states that we've seen, they've opened the doors, is the landlord has to swear under oath that they are not covered by the CARES Act. It's something that the tenant almost certainly can't learn. The landlord can go to their mortgage provider and say, hey, I got my mortgage from you guys. I need to know exactly whether this is a question or not. And they can tell them because they're the customer. But a tenant is not the customer with the bank, so they're not going to be able to get that information. So our best guess remains 20, 30, maybe as high as 50% of Minnesota rentals are covered by the CARES Act, which, as we continue to have eviction moratoriums extended by the governor, it becomes less and less of an issue. If those dates eventually line up, then it won't matter. But if the governor lifts the moratorium right now, the CARES Act is still in place.
All right, so we did get one question in advance that I think you've covered, but I'll say it again. Minnesota suspension of evictions over on June 12th. When can I give notice to terminate?
Yeah, and I never mind having this question more than once. And from that question, I assume that that's a landlord asking the question. Again, the sessions that we do on Wednesday designed for tenants and people that work with tenants, I don't mind any landlord listening in, nor do I mind a tenant listening in tomorrow when we talk to landlord or property managers. But I assume that that question is coming from a landlord based on the way it's written. But if it's from a tenant, then the tenant can give notice anytime they want, as long as it's complying with their lease. So if the tenant is a month-to-month tenant, they can give a notice for the end of July in a traditional setting. If their rent is due on the 1st, they would give notice for the end of July. Right now, the governor's order does not stop a tenant from giving notice. It only works on stopping landlords from giving notices to tenants. And so, yeah, a landlord, based on how we've seen the Attorney General acting very recently, can't give a notice right now, effectively ending or non-renewing a lease for time after the peacetime declaration, because once again, we don't know when that's going to be. But the executive order is vague enough that it looks like the Attorney General's office believes, and until they go to court, we won't know that a judge agrees with this, but it looks like the Attorney General's office believes that a landlord can't give a notice today for time to non-renew after the peacetime declaration is over. And once again, we don't know when this is going to end either. So we've seen a lot of notices that have come and gone. The renewal or the removal date, the date the tenant was supposed to move out, was supposed to be the end of March or the end of April or the end of May. We are right now in the prime season for leases ending. In Minnesota, most leases, certainly 1-year leases or 2-year leases, end in the warm weather months for obvious reasons. Nobody wants to move at the end of January. And landlords know that too. They don't want their leases to end at the end of January because it's harder to refill their place in the cold weather months. So I think April through October are the months when the move outs happen. And the majority of them happen in a 3-month block, the end of June, the end of July, the end of August throughout Minnesota. And so this is when we're going to see this question coming up much, much more.
All right, and we do have a question that's been submitted, but we'll get to right in a second here. Feel free to send in if you have any questions.
That's our only question. People will get to the front of the line
Yeah.
immediately with a question. No
So,
waiting. Wow.
so either via the Q&A box, the chat box, or if you want to raise your hand and speak, that's fine too. So this question is, if a landlord has given a notice to end the lease during the peacetime emergency declaration, I assume that's what that means.
Hmm.
A landlord can't end a lease. So when the peacetime emergency declaration is over, will the landlord have to give a new non-renewal notice?
Yeah, again, I'm a tenant lawyer. I don't advise landlords, although I, talk to them on these sessions, and we've done a lot of speeches over the years to landlords. We even wrote a book, The Landlord's Guide to Minnesota Law, because we believe that landlords that understand the rules are a lot more likely to follow it, so it's better for everybody. But we don't advise landlords directly. But if I were a landlord lawyer and my landlord client came to me and said, hey, I want to get this tenant out as soon as I can, but I don't want to file an eviction. When can I give them a notice to vacate or a non-renewal? My really conservative advice would be you got to wait until the peacetime emergency declaration is over, and then give them a notice based on what your lease requires, whether it's a month or two. That's when you give the notice. Anything short of that, I think, is violating the governor's order and is $1,000 potential penalty and up to 90 days imprisonment. And so I think there's a risk for every landlord that's trying to give mid peacetime emergency declaration notices for times that may be past that peacetime emergency declaration. Because again, we don't know when it's going to end. What if it goes on another 5-6 months? We don't know. If COVID-19 flares back up, it's not impossible to think that the governor might continue to extend it until it seems as though it's more controlled than it would be after the flare up. So anyhow, that's our best answer to that.
Yeah, another question has come in. If a notice is given to the tenant on June 13th and the emergency peacetime is extended, should another notice be sent after the extended date?
To start, again, if I were the landlord attorney, I would not give a notice right now at all to a tenant. I think it's violating the governor's order, and I think it opens a landlord up to the misdemeanor claim that the attorney general's office could enforce. So the question says, basically, is it okay to give that notice on June 13th? I would not be giving a tenant a notice on June 13th. I would not be giving a tenant a notice at all right now for any time. I think it's an attempt to terminate the tenancy. I think it's violating the governor's order, and unless you want to fight that in court and hope for the best, I just can't say that that's a good move on a landlord's part right now. I'm not saying we're not seeing it. We are absolutely seeing landlords trying to give notices frequently. Still, either they don't really understand what the governor's order says, or they don't agree with, I guess, our assessment. But our assessment doesn't really matter. It's what the attorney general's office thinks, and then eventually what a court thinks if it ends up in a court. But I would wait until the peacetime emergency declaration is officially ended before I would give a notice if I were a landlord right now. I just think it's unnecessarily risky. I know landlords want to have tenants move out some of the time for all kinds of different reasons, but I don't like the gamble that a landlord is taking. Again, this is a COVID-19 only situation. Normal times, landlord wants to non-renew a lease unless there's some sort of, if it's manufactured housing or some other exceptions like public housing, the landlord doesn't even have to have a reason to non-renew somebody. But right now, just giving a notice is a risky move for a landlord. This is a COVID-19 exclusive issue, but it is the issue right now if a landlord's thinking about doing that.
Yeah, and again, I'm going to put in the chat a link. This is one of the places that we're referring tenants to. The Office of the Minnesota Attorney General Keith Ellison has actually a form on their website where tenants are able to submit these complaints, and then they are potentially authorized to try to mediate and communicate between the parties.
Yeah, and from what I understand, the Attorney General's office is actually even calling landlords and tenants on weekends, understanding the urgency of these issues that come up sometimes. Threats of lockouts, where the landlord has changed the locks or threatened to change the locks, have increased since COVID-19 began. Landlords realize they can't go file the traditional eviction, so they sort of take, I guess, to just use the common phrase, they take the law into their own hands. And when they take that risk, the Attorney General's office has a new tool to use against the landlord because of the governor's order, arguing that that lockout is an effective termination of the tenancy. So suddenly there's new penalties against the landlord, along with the pre-existing penalties that exist for lockouts or ousters from state statute that have been around for quite a while.
Yep. So not seeing any questions right now. Feel free to submit if you have a question. I'm wondering, Mike, if you could share a little bit about some of the questions we've been getting around amenities during the pandemic.
Yeah, I can talk about amenities, be happy to. So amenities can mean a lot of different things. Kind of the most, what we're talking about is amenities outside of the actual rental unit. So the actual apartment, think of a big apartment building for a second. So a tenant rents their own space where they have a lock to their door, nobody else can come in there. But we're talking about some other areas that might be in the building that the landlord has promised would be included. So we've had questions about swimming pools and workout areas, party rooms. Let's see what else. A music room. I didn't talk to the tenant myself, but somebody talked to somebody that had a music room where apparently you're allowed to play instruments and not have to worry about bothering all the other neighbors. Laundry facilities. We've even had that where the landlord said you can't use the laundry facility anymore, which I think is in a different league slightly, amenities wise, than everything else that I just described. But the question that we've gotten from tenants is, okay, look, I understand why I can't use the coffee bar area or the rooftop deck that we were promised in our building. Now, and I'll freely admit that some of these questions are for really high-end rentals. We don't have any income limitations in our office at Homeline. We advise any renter that calls us up. We're a free service to any renter, regardless of their income. The majority of our callers happen to be, as defined by HUD, low income. But there are some renters that are paying a lot and they're promised a whole bunch of amenities. There's places that have golf simulators and other bizarre things. But anyhow, just like any product, if you're promised something and you are paying for that something and you're not getting the full product, the question is, should you be compensated something back, right? I mean, so if you go to McDonald's and order the Big Mac meal for $5, which should come with a Big Mac and fries and a drink, but they run out of fries, you shouldn't have to pay the full price, right? You should get the discount for what the fries are worth. And so that's the question that we've gotten fairly regularly since this pandemic started. Landlords have just unilaterally said, you know what, we're closing off the workout area, which for some people is one of the reasons why they took a place. Hey, I don't have to worry about a gym membership, and so that's going to save me $20-25 or more a month. And so I'm going to take this apartment for that reason. And so does a tenant have a claim against a landlord for not providing everything that they'd promised originally? And I think that there's no question that they have a claim. The harder question is, what can they do about it? Right now, a tenant can't really force a rent escrow to happen, which is the most common approach they take to try to force a landlord to provide a service or an amenity. I'm not even sure a judge would, if a tenant could file a rent escrow right now, would grant anything as far as forcing the landlord to let the tenant have the access to the gym again or to the party room. I think a judge might say, just don't see how that's going to be controllable. COVID-19, we're all worried about it. So no, we're not going to force the landlord to get you access back to that space. However, in a rent escrow setting, or certainly in a small claims court, conciliation court setting, a tenant could sue for the value lost, right? Just like the Big Mac fries and the Coke, if you're not getting the fries, you shouldn't have to pay for the fries. The tenant would argue, hey, wait, I'm paying, $1,500 a month. This is the list of things that were promised to me. Look at the ad. And the ad probably still has the swimming pool or whatever might be listed in the original ad. So the landlord is still promising this to people to try to induce them into buying or renting this place for a certain amount of time. And since I was promised a swimming pool or the party room or the workout room, I want some money back off of my rent because I'm not getting what I was promised. probably one of the hardest parts of this kind of legal analysis is, again, I think the tenant has a claim against the landlord for this. At McDonald's, my example that I just gave, it's a lot easier to figure out how much the tenant should get, or the customer should get back, because you can look at what the price of the medium fries are, right? And say, okay, I want, $1.10 off, because that's how much the medium fries cost. But the tenant's real task in this kind of request from a landlord, which usually starts that way, the tenant just asks the landlord, hey, can I have some money back for not having this service provided? Some landlords flatly say, nope, no way, no matter what, we're never going to give you a penny. Other landlords are saying, and some have done this proactively, yeah, you're right, you're not getting everything you're paying for, we'll knock down a little bit off your rent. And it's generally not a lot, but it tends to make tenants pretty content. If they hear that the landlord's trying to analyze this fairly, and hey, if you're paying $1,500 a month and the landlord knocks $25 off a month because you don't get access to the 15 amenities they promised, that's not really going to be a big chunk of the landlord's budget, and it might keep that tenant as a customer next year. And you might think, well, why does the landlord care if a tenant stays another year? Landlords really care about that. Turnover is a massive enemy for profitable landlords. If a landlord wants to make a profit, one of their key goals is to minimize turnover. Turnover, on average, according to the industry experts, these are landlord experts, turnover costs a landlord on average 1 month of rent. So a landlord doesn't want people moving in and out if they can stop it. So if they can keep these current tenants, and a landlord right now, by the way, if they have a current tenant that's actually paying their rent, because most landlords that have a giant portfolio have a certain percent that aren't paying their rent because of COVID-19. I mean, they always have a percent that isn't paying their rent, but it's much higher right now. But anyhow, because of that, current paying tenants are a very valuable asset in the landlord's mind. That's their business doesn't work without paying renters. And so if a landlord has a current on their rent tenant, they want to do what they can to keep them into the future. And one way I've sort of phrased this when I talk to landlord groups is that this is just another way to advertise, really, to your current tenants. I'm a reasonable landlord. I know what I'm charging you, and I know what I promised you, and because I can't give you everything I promised, I'm going to knock a little bit off your rent. Whether that's a request from the tenant directly or the landlord just decides it unilaterally. Honestly, it's the kind of thing that tenants post on Facebook in a good way about their landlord. I mean, most posts you see when people talk about their landlord on Yelp or Facebook or any other social media is complaining about their landlord from a tenant perspective. But they will actually post stuff about, hey, my landlord actually knocked this off my rent. I feel like that was a fair deal, and that's what should have been done. So kudos to this landlord. So anyhow, how would a tenant figure out what something's worth? Well, that can be a difficult thing to do. But I mean, with a workout area, I think a tenant can look at the local gyms and figure out what would a monthly membership cost, and maybe get 3 different quotes and take the lowest one and cut it in half. And that's probably going to be an unattackable number that the tenant is suing. I assume that the workout room promised in most apartments is not going to be equal to even the smaller commercial gyms that people can get a membership at, like Anytime Fitness or all those 24-hour ones where you use a key, which tend to be Snap Fitness, I think is another one. They tend to be smaller than the Ys and the Lifetime Fitnesses and the Planet Fitnesses, I think. But anyhow, look around, see what it would be worth to get something roughly equivalent, and then say, hey, I want some money off my rent because of that amount. Something like a party room is a lot harder to figure out. I don't know. It's worth something. There's no question it's worth something. The coffee bar is worth something. Having a dog walking area, especially in a Minneapolis high-rise, it's worth something. It's part of the rent that the tenant has been paying for. So they definitely have a claim. The hardest part is to figure out what's it actually worth, in my mind.
Perfect. All right. Not seeing any other questions. If you have them, feel free to send them in.
Yeah, we can wait a minute. Or as you just noticed from Eric asking me that question, I am a lawyer, so I have the ability to talk for X time on most topics, especially one that I live in career-wise. Landlord-tenant law is all I do. So I am happy to talk for another 15 minutes about what things I think people are dealing with. And we'll give you a minute to ask any other questions, but if not, I'll probably talk a little bit about security deposits because we're in security deposit season. So I'll just wait to see if there's anything more pressing right now. Okay. So as I mentioned, security deposit season is where we are right now. If you're a tenant and you're thinking about moving sometime, you'll care about a security deposit. If you're a social worker or somebody like that that works with tenants all the time, security deposits are and should be a big deal to you and your clients. Most landlords charge in certainly the metro area, but in most of Minnesota, actually. Our hotline is not just the metro area. We cover all 87 counties. About 25% of our calls annually come from outside of the 7-county metro area. So although our office is in Bloomington, we still deal with people that are renting farms or renting a space, and one of their primary goals is to have a spot for their horses to live. We get calls like that certainly every month. A horse question. If you rent a place and you care about where the horses are going to stay, that's one of your prime concerns, because horses are not easy to keep in a lot of spots. But anyhow, I want to talk briefly about security deposits because like I said, it is the security deposit season. My starting advice to renters when it comes to security deposits is actually on day one of the tenancy. So if you're about to move into a rental, or you're working with somebody that's about to move into a rental, is to document the condition of the place. Almost all security deposit disputes are about damages that the landlord claims the tenant caused while they were in the property. And so one of the most valuable things a tenant can do when it comes to a deposit is document the condition of the rental the day they move in. Now, there are a lot of ways to do this. Some landlords really like to use move in, move out checklists. Usually it's on the really tall, legal sized paper, right? The longer letter, longer than a letter size, the legal size paper. And it's got a list of all the rooms, right? The dining room, the kitchen, the bedroom 1, bedroom 2, the living room, whatever. And there's a move in column and a move out column. I'm not a giant fan of the move in, move out sheet for either side, actually. If I were a landlord attorney, I wouldn't use it. If I were, and I'm a tenant attorney, and I don't recommend using it. I prefer photos for both sides, actually, because I think they're a lot harder to refute. From a landlord's perspective, sometimes they say, well, I really like the move in, move out checklist, but especially in the metro area, if you have a security deposit dispute, it's going to end up in conciliation court, where they, in Hennepin County, they devote a day and a half in conciliation court every week to just landlord-tenant disputes. About half of those are landlords suing for rent that's been unpaid. The other half are tenants trying to recover security deposits. So they see a lot of these cases. And these referees or judges that see these security deposit cases look at these move-in, move-out checklists a lot. And the problem with this, again, from the landlord perspective, is so many of these move-in, move-out checklists on the move-in side, the move-in column, at the top of the column, it's got the letters OK written down, and then there's an arrow down the entire page. OK, arrow, which implies that the place was essentially perfect the day the tenant moved in. Maybe it was perfect. Maybe it was a brand new place. I guess it's possible, or maybe everybody was in a rush. Honestly, the landlord doesn't have much of an incentive to find anything wrong with the place on day one when the tenant moves in. It doesn't really help the landlord. I'm not saying they're going to lie, but they're not going to look that hard. There's not, again, much of an incentive. Whereas on the last day, when the tenant is moving out, so we're going to fill out that move out column, when you look at those, every other line or even more is filled in with stuff that's wrong with the place. Now, if I'm a judge or a referee and I look at these again and again and again, and I notice okay at all these move-in columns, I'm going to start to wonder about how accurate those are. Because again, on move-in day, the landlord's in a rush. Maybe they have 15, 20 of these to do, depending on the size of their building and what time of the year it might be. So it's really up to the tenant to try to stand their ground and say, wait a second, I'm going to open every cupboard and look in it, just like the landlord will on the last day that the tenant is there. So what I always tell tenants to do is A, look in all the troubled areas, the traditional troubled areas. Open the oven. I guarantee the landlord is going to open the oven the last day the tenant is in the place. Look at the bathtub. You know, look around the bathtub. How's the caulking look? Is there a weird rust stain? Get a picture of that as compared to just writing it down. Get a photo of it. Same thing with that oven. But the big money when it comes to deposit disputes is on the floor. That's where a tenant really wants to focus on day one before they move anything in. No boxes, no furniture. They walk around with their phone or a camera. And again, this is something a social worker can tell a tenant to do when they're moving in. It's really useful advice. Walk around and take photos. And you can even help them find anything that might be wrong. And like I said, the big money's on the floor. Sometimes it's going to be a problem with tile or hardwood or even cement, I guess. But generally what we're talking about is carpet. We want to see any problems with the carpet and take a good couple of pictures with it. So a stain, a tear, a rip, a cigarette burn on the carpet, a good up close picture of that, and then one taken from a standing perspective. So reason why I say to do that is because if you take a picture of something really up close, it really alters what it really appears to be. It's hard to tell sometimes what you're even looking at. So you'd have an up close picture showing how obvious it is up close, and then another picture maybe standing height to show that it's not just a tiny thing that you used a telephoto lens on or something like that. So those photos, those before photos, are ones that tenants almost never have when they go to small claims court to dispute a deposit being kept. But those are the ones that matter the most. Now, tenants frequently remember on the last day that they're in a place to take pictures on the way out the door. And again, I mean that phrase, on the way out the door. It should be the last thing they do, right before the landlord gets the keys. All the boxes are removed, all the furniture's gone, all the cleaning has been done. Ideally, the tenant would then take overall pictures showing the overall condition. Look in the troubled areas, the inside of the fridge, the inside of the oven. But those before and after pictures, if the tenant has them, can be the difference between getting a deposit back and not. Our office advises at least 100, if not hundreds, of clients on how to do a small claims court case every year. We kind of walk them through the whole process from filing the case to what to emphasize when they get to court, and we'll sort of prepare them on how to do court. And tenants that go into court with before and after pictures, I mean, they win 80, 90% of the time, but I mean, you have to think about who they are to start with. They thought they were getting ripped off, right? I mean, many landlords return deposits in full, or at least a sizable percentage of it. But the landlords that keep deposits, if a tenant wants to stand up against that and they think they've been treated unfairly, those before and after pictures can mean a lot. The other really good useful piece of evidence would be witnesses that saw the place, ideally, on day one, the day the tenant moved in, and then they also help them move out. So if you have any witnesses that are available that can be witnesses before and after witnesses, those can be really valuable too when you're trying to win a deposit case as a tenant in conciliation court. Oh, and Eric has just posted our form letter on asking for a deposit to be returned on our website. Yeah, so we have 12, 15 form letters on a variety of different topics. Repairs is the most common and popular form letter that people download from our website every year. But we have one on when a landlord is allowed to stop a guest from coming in, privacy rules, problems with neighbors, a landlord trying to charge a tenant for bed bugs. We actually have form letters for those and many other topics that come up on a fairly regular basis. They're free. They cite statutes. They look really official. And there are many times when a tenant simply sends our letter after they've filled it out with their information that relates to the issue. And that letter resolves the problem on its own without a court case ever being filed, because the landlord realizes the tenant is doing something to figure out what their rights are. They're citing some rules that certainly look like Minnesota rules. So maybe they should rethink their position and talk to the tenant, and maybe negotiate something that both sides can live with. So those form letters are a really wonderful resource for tenants or people working with tenants to try to solve problems many times before court is even really considered seriously.
All right. Well, what I will do is remind folks that I don't have a slide for that right now. I'll just remind folks that we do these every week on Wednesday and Thursday, and if you're participating, you'll get a follow-up email with a link to the recording and with a place to sign up for registering for the next week. But they're always on our website. On the right-hand side, there's sort of a feed of most recent news, and we have the registrations for both today and tomorrow for the landlord webinar, and then either later today or tomorrow we'll have a new registration for next week.
Right, next week's session will be after the decision by the governor, and so those are almost always the ones that are attended the highest for us, because people want to know exactly what the new rule will be, whether the governor extends the eviction ban or does not. And so we'll be talking about all the ramifications of the governor's decision on Friday, next Wednesday for sure.
Yep, and again, right now, June 12th, the end of the day, June 12th is the expiration, but likely we'll hear some news out of the legislature and the governor's office that day, or before possibly, but he's waited till, like Mike said, the last one was, I think, a press conference that he held at 6 p.m. on, what day was that? The 13th of May, I think.
I think that's right. It's a 30-day extension. It's not a full month. So it's just, pull out the calendar and count 30 days from there is all it is. Yeah.
Yep. All right. Well, I think we can wrap it up a few minutes early here. And thank you all for participating. And maybe we'll see you next week.
Thanks.
Thank you, everybody.